versus Jackie Lee Moore, appellant, file number 2023-237141AR. I have Jennifer L. Bruggeman, P66066, appearing on behalf of the Lenawee County Prosecutor's Office. And I have Katerina L. Dumont, P85609, appearing on behalf of the defendant appellant. This is the date and time scheduled for oral argument. So, all right, so I believe Ms. Dumont.
Yes, Your Honor. We're asking for the jury trial to be reversed and set for another jury trial based on Judge Shaler's conduct throughout the entirety of the trial and before. We're arguing that she robbed the jury of its province to be the fact finder based on her biased commentary, her bullying of defense counsel, the fact that she essentially was the prosecutor as opposed to operating as a judge throughout the entire trial. The most egregious showing of partiality was with regards to her questioning of Mr. and Mrs. Moore when they were on the stand, cross-examining them once defense counsel was concluded with regards to that. She indicated her own opinion with regards to those questions. With regards to People versus Cole, defendants, witnesses, and defense counsel showed an unwarranted partiality, and it may have influenced the jury. It's not a must. There's no way to show the way that she acted and showed her opinion and bias towards defendant and his witnesses and his counsel. There's no way to show what impact that had on the jury. She didn't cross-examine or interject with regards to the two officers that testified. And in fact, she admitted one as an expert witness, which was not necessarily a harmless error because under the totality of the circumstances with People versus Stevens, it's reasonably likely to influence the jury by creating an appearance of advocacy or partiality against a party. And with regards to the totality of the circumstances and throughout the entire transcript, we would argue that she was biased and broke that veil of impartiality.
Thank you, Ms. Dumont. Ms. Bruggeman.
Thank you, Your Honor. For the most part, I just rely on my brief. I think I lay out or address all of appellant's concerns and arguments, especially in light of the bias argument. First of all, this was addressed by Judge Moore from Monroe when they filed a motion for disqualification, which was denied. Again, they raised some additional issues in their appeal under the same argument, if you will, that Judge Shaler was biased and pierced the veil of judicial impartiality. I think that when you lay out when you look at the entirety of the transcript, as well as the body cam evidence that came in, and the fact that the jury was instructed appropriately as far as what their role was, what the judges and the attorneys' roles are, as far as that their questioning and their comments are not evidence. Juries are presumed to follow their instructions. Again, I think I lay out all of the Stevens-Swilley factors, which again are a non-exhaustive list as far as looking at judges' bias or potential bias. And I address those things. Obviously, here and there, if you look at it just piecemeal, it may appear that way, but when you look at, again, the entirety of the transcript, it is clear that Judge Shaler interjected or clarified testimony or sustained objections or what have you on both sides. So a lot of the questioned behavior of Judge Shadler occurred outside the presence of the jury. So I point that out as well. As far as the officer being admitted as an expert, I think the type of expert that he was deemed to be probably was error. I did concede that in there, but I do believe that that was harmless. Again, when you look at Sergeant Adams' testimony, his testimony is not anything that rises even to the level of an expert. The content of his testimony is not specialized in any way. It really was just, what was your investigation? What happened? And it really affirmed everything that actually the jury saw in the body cam evidence. So what was presented to the jury from Sergeant Adams really was nothing other than what an officer would testify to normally. And again, the jury was appropriately instructed on what how they should view a police officer's testimony as well as an expert's testimony, and they weigh the credibility of all witnesses, including police officers, and they give that weight or credibility on the expert's qualification and testimony. So again, I would just simply rely on my brief for the remainder, and certainly this is not an instance where Judge Shadler was biased or partial towards the prosecution, and certainly not they have not met that heavy burden, and it is a very high burden that they have to meet to show that she was biased, and I would ask the court to deny relief in this matter.
Ms. Dumont.
Your Honor, first of all, with regards to asking for Judge to disqualify herself, Judge Brown of Monroe County did review that. That was for sentencing purposes, and that was based off of a transcript of an in-camera review of Mr. Moore's daughter from the first trial. That didn't include anything with regards to the transcript from the second trial. We're arguing we have met our burden. The jury instructions can't cure what Judge Shadler did with regards to this trial and how she acted. And finally, we would just rely on our brief and argue that a wrongful conviction is never harmless.
Very good. All right, so I'm going to take this under advisement. We will issue an opinion. All right. Thank you very much, Mr. Moore. Yep, you're all set. Jacob Kahn, are you here on a specific case?
Yes, good morning, Your Honor. I'm here on Mickey Smith versus James Edward Armour.
There we go. All right. Sorry, I didn't turn the page. This is in the matter of Mickey Smith versus James Edward Armour, file number 2023-237124CK. I have attorney Jacob Kahn, P85936, appearing on behalf of Mickey Smith. And are you on this case? What's your name? All right, why don't you come up, Mr. Armour?
And Your Honor, in the interest of judicial economy, plaintiff is willing to stipulate to set aside the default on a couple of conditions.
All right, so Mr. Armour did file a motion and affidavit to set aside the civil default and set it for hearing today. So Mr. Kahn, what would be those conditions?
Just two things. One, plaintiff would like the chance to amend its original complaint. Some additional information has been uncovered based on the defendant's motion to set aside default. And then second of all, just as a housekeeping matter, one of the defendants in this case, Your Honor, is an LLC, and it needs to appear through an attorney.
Okay. And it's Two Hippies LLC, correct?
That's correct.
Okay. All right. So, all right. So, Mr. Armour, are you part owner of that?
I was, yes.
Okay. So you're no longer involved in Two Hippies?
Two Hippies doesn't exist anymore. Two Hippies was a company that went bankrupt.
Okay. So do you understand you can appear on behalf of yourself, but you can't appear on behalf of the corporation is what they're saying?
No, I don't understand that.
So, have you sought counsel?
With the company going down, I was working at that company, so I was paying myself. I haven't had.
So
I haven't-
my question was, have you sought counsel?
No.
Okay.
I don't.
So do you understand he has no objection to setting aside the default, but they want to amend the information to reflect what was pled in your motion, and limited to that? And then, do you understand you can't represent the corporation?
I do now that you told
Okay.
me that.
So do you agree to those terms?
I don't know how I'm gonna get an attorney, Your Honor, but
I didn't say that. So,
if that's how I get to move forward to the next hearing, then I really don't feel I have a choice. So yes.
so there are two defendants, you plus Two Hippies.
Okay.
Do you understand that you're not one and the same?
Well,
You kind of are, but you're not.
and isn't that what he's arguing?
Yes.
That Two Hippies is me and that I'm,
No.
well, he's saying because I'm not in good standing, that I am acting Two Hippies.
That's not what he said.
Okay, well, if that's the case, then I will have to find a way.
Okay, all right. So I'll grant the request to set aside the default. And since you asked for those specific things, Mr. Khan, I would ask that you prepare the order.
I certainly will, Your Honor. And how about 2 weeks for the amended complaint and then 3 weeks for the defendant to answer it?
That's fine.
And may I
And
serve that
then-
by mail? I don't need to get a process server back out. Can I serve that by mail to the defendant's address?
Can you receive that by mail?
Sure, that's fine.
Okay. And I guess I'll need another pretrial. So I'll give you a date to put in the order as well. All right, Mr. Khan.
And just to clarify, because I had to serve this, I apologize, but I had to serve this by alternate service. So, sir, when I mail that complaint, 9024 Carlton, is that correct?
Yes.
Okay.
So I'm going to set this for a pretrial February 12th at 3:20. All right.
Perfect. Thank you, Your Honor.
2/12 at 3:20, and then you can put that in the order as well, Mr. Khan. All right.
And just for the record, if the defendant would like to call me to try to discuss a resolution, my office is always amenable to those conversations.
Okay. So make sure you reach out to him to discuss it. Okay.
That's fine.
Okay. All right. Thank you.
Thank you, everyone.
So the next contact will be from mail from him in February.
Well, you can reach out to him too and try to resolve the case. But yeah, so he'll file an amended complaint and then you gotta file an answer, all right? Okay, thank
Sorry, I
you.
didn't mean to walk away while you were still talking.
It's okay. It's okay. I'm always still talking.
Well,
You're fine. Thank
all
you.
set.
Yeah, you're set.
Have a good day.
You have something for me?
Yes,
Let me see.
only once a year.
I know. but it's okay. The tray around, please.
13 years, or no, 11.
Hang on.
Up here.
Yeah.
Turn the line.
Yeah.
All right, you don't have. Family.
Police officers? No.
No. Yeah.
Oh, yeah.
And-
He's like a fourth cousin.
Oh, really?
Yeah,
Curious.
they're all related.
All right, thank you, bye-bye.
Yeah,
Thank you.
I'm just testing it out
Just,
right
you
now,
know,
yeah.
Mr. Bowen.
Yeah, he's gonna take it down.
Yeah.